folks, welcome back to Contract B, and today we are looking at week 5, which is the topic of illegality and void contracts. I've been having a little bit of a play around with the study guide, as you will have seen. It doesn't really matter if you've already printed it. If you have printed it, just run with what you've got. You will pick up any differences from our excursions in this video, I'm sure. If you haven't, then go and have a look at the revised study guide. All I've really done is tried to improve the structure a little bit to make it line up with the text a little bit more for you. However, having said that, the way that the text goes through the various issues in relation to illegal contracts and void contracts, I think perhaps could be clarified. And so what I want to do is split things up a little bit more clearly, perhaps, for you today in the video. Illegality seems like a fairly simple concept, doesn't it? In Holman and Johnson, it certainly does seem like a simple concept that no court will lend its aid to a man or woman who founds their cause of action on an immoral or illegal act. So it seems fairly straightforward, doesn't it? But unfortunately, that is about as unassailable as a piece of Swiss cheese, that particular concept. And there are lots and lots of holes that have been poked through that very broad statement in Holman and Johnson in the years since the concept has arisen. And in fact, there have been so many holes poked in it that Carter says that the topic of illegality is one of the least satisfactory branches of contract law. So just when you thought, ooh, mistake or undue influence or unconscionable conduct or estoppel were challenging, well, illegality is probably just as challenging and perhaps a little bit less settled than those other areas. However, what we're going to try and do in this video is try and get a little bit of extra clarity for you. So the way I want to break it down is a little bit different to the way that things are discussed in the text. In the text, they discuss void contracts up front, and they talk about void at statute and void at common law, and then they talk about illegality under statute and illegality at common law. Here I want to make things real simple. We want to cut to the chase. We want to talk about illegality because we've already touched upon the concept of void contracts before. You're not a stranger to the whole notion of a contract being void. It was certainly one of those results that could ensue if, for example, the contract was tainted by duress or, for that matter, certain forms of mistake. So the way that I'm going to break things up for us today is firstly to shoot straight for the main game, which is illegality. And we're looking at the result of illegality, and then we're going to break it apart under statute, common law. Then we're going to look at the result of a contract being void, and then we're going to look again at void contracts under statute and at common law. I hope it will make a little bit more sense to you, and it will help us to unpack the potential remedies that we can seek given these two potential results that might flow from certain kinds of contractual provision. So, without further ado, let's look at illegality under statute. And these are actually illegal contracts. This is the serious stuff here, okay? In all of this, you need to bear in mind that the result of a contract being declared illegal is that the necessary result will be that the legal doctrine of ex turpi causa follows. And that is a pretty scary little result to flow from a decision that a contract is illegal. And we'll cover that off in just a moment. Illegality via statute, first of all, we have to look at the case of Nelson and Nelson. That breaks it down very easily for us into 3 different circumstances where a contract might be declared illegal. That is the result of illegality, and then therefore the application of the ex turpa causa doctrine. The first is obviously where the statute expressly prohibits the making of that particular kind of contract. Express illegality. Okay, the next one obviously is implied illegality. So the statute doesn't actually say thou shalt not make a contract for X, but it simply prohibits things like the doing of conduct, for example. And in those circumstances, the contract as formed or performed may be impliedly illegal. The final one is a kind of new kid on the block, and that one involves contracts that are prohibited not where there is an express prohibition on those kinds of contract, not where there is an implied prohibition on those kinds of contract, but where they are contrary to this broader notion of public policy as evidenced in the statute itself. So, looking at express illegality, really this is pretty easy. The legislation itself simply prohibits the kind of contract that has been entered into in your particular circumstances. So we have the illustrative case of Baird and Magripolis, and in that case we had Baird subleasing land to a couple of Greek men who spoke very little English. The contract required them to become naturalised or pass this dictation test, which was designed to assess certain minimum levels of competency in the English language. The contract took effect straight away, and the requirements for them to either become naturalised or pass this dictation test operated as conditions subsequent to the contract becoming effective. So the problem was there. The contract became effective, title was passed, the Magripolis folk spent a fair bit of money in improving the land. They did become naturalised, but the problem was that the legislation, the Leases to Aliens Restriction Act, how about that for a statute name, passed in 1912, so you can see there the relevance to the First World War. Prohibited agreements to aliens who hadn't passed the dictation test, and it said that they would be void. In that particular circumstance, where the agreements themselves were prohibited, it was said that in circumstances where there had been no dictation test, the contract was expressly illegal, and therefore the result was that it was null and void. So that's illegality in terms of an express prohibition in the legislation. Then we have illegality that has been implied by the terms of the legislation. This is a little bit trickier, obviously, because you haven't got the dots all being connected for you quite nicely right there in the text of the statute. You've got to kind of fossick around and forensically go through things to work out whether or not the statute does, in fact, require the contract to be declared illegal. And how do you do that? How do you engage in that forensic examination? Most importantly, you need to look to the object of the statute. That's going to be your guiding light in all circumstances. So you've got to look around, you've got to go to the objects clause if there is one. If there isn't one, you need to look through the Act to see what it's designed to do. And if the object can only be achieved by prohibiting that particular kind of contract, then that's what must have been intended by the legislators, and the contract will be illegal. If the object is consistent with prohibition, that is, it could be achieved by prohibiting a contract, but equally it might not, then you've got to look at other factors. And predominantly here, courts tend to, the first port of call is usually looking at what kind of penalty is imposed in that particular circumstance. How is the penalty structured? And the courts ask themselves, is prohibition, that is illegality of a contract, an unwarranted additional civil penalty? Is that entire loss of contractual rights an unintended imposition in light of the other penalties that are structured in the legislation? And you've got to look at other things like, well, is there an issue of public safety? If so, could be more likely to be illegal, is the result of illegality disproportionate in the circumstances. Now, if prohibition is not necessary and the objects of the statute can still quite happily be achieved, notwithstanding this contract, then prohibition won't be implied into the legislation and the contract won't be declared illegal. So here we look at the illustrative case of Lango Pastoral. This is the case where the plaintiff granted a loan to the defendants. Obviously, the defendant then defaults and the plaintiff tries to enforce the loan arrangement. The debtors, that is the defendant and the guarantors, argued that the mortgage and guarantees, the documents in those in that loan circumstance, were illegal. How did they argue illegality? Well, the Banking Act 1959 prohibited a company from any banking business in Australia unless they had the relevant authorities prescribed by that legislation. Penalty was pretty high, $10,000 per day, regardless of how many contracts had been entered into to further this company's banking business in Australia without authority. Now, obviously, the plaintiff in that circumstance had no relevant authority, so the question was, could the plaintiff enforce the loan arrangement there? In terms of implied illegality, what the court did, as I said before, first port of call was to look at the penalty. Well, in that circumstance, there was a very high daily sum that was imposed upon the businesses that were contravening the legislation. And because there was a daily rate imposed, the court said, well, it doesn't seem like Parliament really intended to penalise each contract that had been made without the relevant authority. It was just the fact that the company was carrying on business without that authority that was the important point. And moreover, they said if all of the contracts that had been entered by a company without the relevant legislative authorities was rendered illegal and therefore obviously void and unenforceable, that would be a really disproportionate result. In this circumstance, all contract, as you can see down there, down the bottom, I said to prohibit all contracts would have been gravely, actually that should be gravely, proofreading, inconvenient. And it was an additional injury to innocent parties. All sorts of contracts, not just loan contracts, could have been declared illegal and therefore unenforceable, not intended by the legislation, and therefore not illegal. Fairly straightforward, I guess, in that particular set of circumstances. Not always as straightforward as in Lango, but it does give you a good idea of what implied illegality is all about. Might be a little bit more complicated where you do have issues of public safety, and the text talks about the Pretorius case where some therapeutic goods were supplied without the relevant authorities prescribed by the therapeutic goods legislation. Obviously there where you've got tablets and potions being supplied that might cause an issue of public safety, the court's going to have a long hard look. In that case, the contract was declared illegal. So that is implied illegality. Where we have this broader notion of statutory illegality on the basis of public policy, I think it was most clearly set out in the Fitzgerald and Leonhardt case. Neither the text nor the casebook really seems to look at this in a terrible amount of depth, but I do want to go through it with you because I think it really makes the issue quite clear. In that case, we had an owner that engaged a driller to construct a bore. And this whole business of constructing a bore and the drillers being required to be licensed and all of that stuff was regulated by the Water Act that applied in the Northern Territory. Now, in this circumstance, the driller had been licensed according to the legislation. The problem was that the owner themselves didn't have a permit to construct bores as was required by the Water Act. The driller did their work, and then the owner very conveniently said, oh, I don't have the relevant authorities, I don't have the relevant permits, the contract is illegal according to the terms of the Water Act. Now, that would have been quite convenient, wouldn't it? Because then the owner got their bore, but they wouldn't have to pay. The defence of illegality failed there, but it's interesting to see the court's discussion here. The court says the contract was not expressly prohibited. The Act did prohibit the owner doing acts, that is getting a bore constructed, without the authority of a permit. An agreement that the owner engage in such activity may have been treated as impliedly prohibited, but the pleadings didn't actually ask the court to consider that the contract was illegal impliedly because of the Water Act. That was not the owner's case. So the owner looked to this more broad notion of public policy, and the court said the question is whether, as a matter of public policy, the court should decline to enforce the contract because of its association with the illegal activity of the owner in getting the bore constructed without the relevant authority. The refusal of the courts to regard the contract as enforceable stems not from express or implied legislative prohibition, but from the policy of the law commonly called public policy. So again here, where public policy is the root of the illegality, you need to look at the scope and purpose of the statute again. That's going to be the first cab off your rank. Okay, look at the purpose and scope. In that situation, the Water Act vested in the Northern Territory the property right to use, flow and control of water, obviously, because the state needs to be able to control such things as important resources like water. The property owner's right was therefore subject to the Northern Territory controller's right to impose restrictions around the whole issue of constructing bores and getting water out of the land, and they could impose things like, oh, you can only take out so many litres per day, flow restrictions and so forth. Obviously sensible if there's droughts and so forth. It imposed the licensing systems and so on. The driller here, as I said, had complied with all licensing requirements. The driller's claim for payment did not depend on the owner's illegal conduct, that is their authorisation of construction without the relevant authorities. So here, in those circumstances, the imposition of illegality would be disproportionate to the seriousness of the breaches and unnecessary to protect the object or policy of the statute. So in that case, contract not illegal, driller could get their money. Okay, no real problem there. That's illegality via statute. All three of those aren't really too hard to get your mind around. The only potentially tricky one, I guess, is where contracts are impliedly illegal via statute. And then, as I said, you've got to go through that more forensic exploration of the legislation to try and work out what's the object and so forth. So this seems like a pretty good jumping off point to end part one of this series, and I'll continue with illegality at common law in part two next video. Thanks, guys.